Welcome. Welcome to A Taste of Justice with Professor Angela May Kupenda. I'm sure you noticed that I'm not in my usual study room to record this clip. And I have some notes with me today because I want us to have a very serious but somewhat relaxed conversation. You see, this chair that I'm sitting in, this is my mother's chair. She is now passed away. But I sit here today because it reminds me of the many conversations I had with my mother about race. As a little Black girl starting about the age of 4 or 5, I noticed the inequality in society and the demeaning ways that Black people were referred to on television and even by some of our government leaders. I would ask her questions about that, and she would answer me with nuances, with honesty, wisdom, simplicity, and in an attempt to preserve my self-dignity. We had these conversations from around my age of 4 or 5 all the way into my 50s when she passed away. So I thought I would talk with you from her chair today, hoping that I will tap into some of that spirit of wisdom and honesty and simplicity and nuanced and preserving self-dignity as we talk about race and unequal treatment today. So the title I've given this talk, and I'm gonna have to stop rocking. I love rocking in this chair. The title I've given it is What Slavery Got to Do with It? Race and the Equal Protection Clause. And what I want us to notice today, rather than just going case by case, I want us to look at some themes, how slavery as a theme still rears its head in many of the inequalities, racial inequalities we confront today. And maybe then, if we understand where some of this comes from, maybe then we can move on to the promises of the preamble of our Constitution to establish justice. So I'm doing a take, what's slavery got to do with it? I'm thinking about Tina Turner and her lovely song, What's Love Got to Do with It? And her book and her movie. That's the take I'm intentionally doing on the title. So today I want to just mention several points, about 5, in my argument as to what slavery has to do with it. And at the same time, doing a bit of an introduction to the reading. My students, they finally have their books. I don't have to produce materials for them. And in cases, they have their books and they are reading the full opinion in the cases I will briefly mention today. So first, what's slavery got to do with it, with this conversation about racial inequality? Well, inequality. Well, I would tell you first, slavery provides the roots for our reluctance to openly discuss race and the law in public, and our way of pretending that inequality does not really exist, or that it is really not that serious. You see, the framers of the original Constitution, they also had some hesitation in addressing race forthrightly in the original text of the Constitution. they never used the word slaves, never, even though the Constitution, the original text, in many ways supported slavery. I guess they were a little too proper, too genteel to use the term slaves, while all the time inserting provisions in the Constitution that continued to contribute to slavery, the slave system in America. For example, Article 1, Section 2 is the 3/5 compromise. Now, I don't think that meant that Black people got 3/5 of a vote and two of them together can have a full vote and some change. It did not mean that. It meant they were counted for the benefit of the slaveholder, of the slaveholding states. Check out that provision. It's noted again at the bottom of this, but they never use the words slaves. They say 3/5 of other persons shall be counted. Article 1, Section 9, it protected the slave trade in a constitution with a preamble with the beautiful words about justice. Article 1, Section 9 specifically states that Congress would not be able to prohibit the slave trade for at least 20 years, but it never uses the word slaves. Read it for yourself. They knew what they were talking about. Article 4, Section 2, Clause 3, it said that slaveholders could go into other states to get back their human property. Now, all of these provisions, none of them are saying the word slaves. They're very subtle, but they are supporting slavery. And I think that's why today we have some difficulty in talking about race and the Constitution. We rather say, oh, it's just a few knuckleheads, as opposed to dismantling the systems that have been there with us, sadly, from the beginning. My second point, the system of slavery made it unlawful to teach slaves, and this educational inequality from slavery is still rooted in our educational disparities we face today. Now, check out the narrative of Frederick Douglass. I've mentioned him to you before, and he said that he overheard his master telling his mistress, don't teach him how to read. Don't teach that slave to read, because he will forever be unfit to be a slave if he learns. And look, Frederick Douglass surely wanted to be unfit to be a slave. He wanted to change his condition. So this thing about not educating individuals to bind them into the system of old goes all the way back to slavery. You know, we can think about, like, before Brown versus Board of Education, the Supreme Court said, oh, let the school districts figure it out. And in many places, they figured it out by giving more funding to white schools than they gave to Black schools and schools where other people of color were attending. Then, of course, we had Brown versus Board of Education in 1954. But I think I've told you that Brown was decided before I was born, but I did not attend a class with white students until 1970, as the South and also other places too resisted the notion of educational equality and of integration, or rather desegregation. We had the Little Rock Nine, we had governors standing in schoolhouse doors, all types of things. Then subsequently, the Supreme Court ruled in a case that's noted in the bottom in the notes, make sure you read those. The court said that education was not a fundamental right. That education is not a fundamental right. So theoretically, states could close all of their schools today. But the court said if you open them, you have to follow the law. But since education is not a fundamental right, we have these great disparities in funding. Well, after Brown was decided, there was a lot of white flight, like from the city where I was living. And people say they left for different reasons, but this all may go back to the whole theme about our being unwilling to talk about race publicly and openly. Even in one school district, in the Parents Involved versus Seattle School District, where they attempted to do some further integrating and diversity in the school system, the court actually said they went too far and that it was de facto now. It was not de jure or a matter of law, and that the school district couldn't go that far. Oh, you have to check that case out. So second, the system of slavery, in my view, feeds into the continued educational disparities that we have. Now, look, I keep saying in my view, let me clarify here. I am Angela May Kupenda. I'm a professor at Mississippi College School of Law. All interpretations of these cases and principles are my own. I am not speaking for my school or for my students. So I just want you to understand that as I exercise my academic freedom in sharing these principles with you. Now, the third one, back to number 3. The third one is slavery denied citizenship rights to slaves and even to free Blacks. And now the continuing struggles, we still have continuing struggles about birthright citizenship and the ability to engage as full citizens with the voting challenges we face in our society. Now, going back, this case, Dred Scott, is mentioned in the notes at the bottom. You have to read it. It is amazing. So we have these slaves that were taken by their masters into free territory. Look, a long time ago, when I used to play checkers with my cousin, he would always talk about, checkers, the little black and red things you play. It's a fun game. He would talk about get your king on the Mason-Dixon line and stay on that Mason-Dixon line and you won't be caught. And he was a little old. He's a little older than me. He made some references to race that I didn't quite get. I was just trying to figure out how to win the game. But that Mason-Dixon line divided pretty much slaveholding from non-slaveholding states. And so therefore, slaves who were trying to get free, if they could just get to that Mason-Dixon line from the South, then perhaps they could get some more help on the other side and maybe live as free. But in Dred Scott versus Sanford, the court said, no. Here we had this man, a Black slave and his family. They had been in free territory. And then when they made it back, they had thought they would be able to buy their freedom. But then they think they're about to be sold and separated. That happened a lot to Black families then. And so he brought suit. Actually, a former master of his helped him with the case. Can you believe that? Well, it's true, read about it. And so he brought suit. And you know what the court said? So in civil procedure, there's this concept called diversity of citizenship. in order to be in the jurisdiction of the federal court, there has to be a federal law at issue, federal issue, or diversity of citizenship. Well, the court in Dred Scott in 1857 said, you're not even a citizen. As a matter of fact, the court went on to say that Blacks, whether free or slaves, were not citizens of the United States. And the court added some language saying that Black people were of an inferior order, and so therefore were not entitled to citizenship. Now, as a result of this opinion, this means basically the whole country's been slave, because slaveholders can go into any area in search of their former slaves or lay claims on individuals as their former slaves. And of course, we had the Civil War, the Emancipation Proclamation, the Reconstruction Amendments. So why am I still talking about this? Why am I still talking about slavery, denied citizenship rights, and questioned birthright citizenship? Because it's still with us, the citizenship issues. In Korematsu versus US, the case is mentioned below, Japanese American citizens were put in internment camps. Their loyalty was questioned, but not really. They did not do an investigation of their loyalty or disloyalty, just rounded them up. Now, ultimately, the court did, not the court, Congress. Ultimately, Congress gave them some reparations, which did not completely pay them back, but some. And in a later case, the court has said, why do you keep talking about Korematsu? That's an old law. But the court has not done the careful analysis it usually does when it's overruling law. So can the government just round us up based on our racial identity, even though we be citizens of the US? Well, Korematsu, Trump versus Hawaii case claims it's overruled. I put the sites, you can check it out and make that determination for yourself. Also in Shelby versus Holder is a case dealing with voting rights, and that's from 2013. But the court kind of eliminated critical portions of the Voting Rights Act. So these issues going all the way back to Dred Scott still seem to be with us in terms of racial equality, citizenship, and the important right of citizenship, the right to vote. So fourth, we support slavery by allowing the subtle racial inequality and painting a different story about slavery and those conditions than were the case. There's this case, Washington versus Davis. In Washington versus Davis, this exam is being used that eliminates many of the Black applicants. And the court says, oh yes, we see the test. Oh yes, we wonder about its relevance, but here, it's okay. It's constitutionally, it's not unconstitutional, even though it brings about these great racial disparities. And similar concerns have been lodged over the years against the LSAT law school admission test and other standardized exams. But I just gotta tell you about this case called McCleskey versus Kemp. Check it out and check out something called the Balder study. Now, people have different views on the death penalty. And sometimes we're just uninformed and we believe that if a person commits a certain crime, regardless of who they are, they get the death penalty, or another crime, regardless of who they are, they do not. But in McCluskey versus Kemp, there was this study done by a scientist called the Baldus, B-A-L-D-U-S study. And his statistical regression showed that the number one factor that determines whether a person gets the death penalty or not is not the nature of the crime. It's not how horrendous the crime may be. The number one factor was race. His study showed that the number one factor is when the victim is white and when the defendant is Black. So in McCluskey versus Kemp, this Black man who had been sentenced to death, he brought suit saying that the application of the death penalty was unconstitutional because it was racially biased. The court said, sorry, you got the death penalty. The court said that, well, he had to show, according to the court, that he himself personally was discriminated against, not Blacks as a group. Now, of course, there was a dissent, a strong dissent, but it was a dissent. It was not the majority. The dissent said, now, wait a minute. We cannot have a system in place where the number one factor as to whether you will be executed is your race. We need to fix this. And the majority said, well, to fix it, we have to redo the entire criminal justice system. And the dissent said, let's do it. But the majority's holding prevailed, and they said that you can't, for a constitutional violation. Now, statutory violation, if Congress passes certain laws about discrimination, that's different. That's different. But for a constitutional violation, the court says you got to show that you personally were affected because of your race. Or it has to be a situation like in the unequal case where the court said that there was an absolute zero. No whites affected, all people of color affected. If you don't have that type of situation, the court said that you would not prevail in your constitutional claim, and here the defendant would still be executed. Now, there are more, but I'm going to leave the others for you. This is a taste of justice. I want you to think about, as you look at cases and situations, you listen to the news, you debate issues, I want you to question the unequal treatment and whether the unequal treatment has a root or a branch back in slavery. And what then is the thing to do about it in order to bring about more justice? And also at the bottom, I've noted some of my writings about growing up in Mississippi as a girl that you may find of interest. Again, this is A Taste of Justice with Professor Angela May Kupenda. Goodbye.